And a balanced approach would really consist in not over relying or under relying on the artificial intelligence, but we really have to raise in the minds of directors the fact that there is something called automation bias, where people will feel inclined to follow the decision of the artificial intelligence just because they think that it is actually correct all the time. And this is not true.
Hi, and welcome to another episode of the Law of Tech podcast. In this episode, we'll be exploring some of the issues at the intersection of AI, directors, and liability. And for this, I'm joined by Samar Ashur. Samar is a solicitor admitted at the Supreme Court of New South Wales, Australia, and she currently practices in the areas of corporate and commercial laws. In addition to practicing law, she also has a flair for researching the areas intersecting corporate law, commercial law, and artificial intelligence. Samar, thank you so much for joining me on the show today.
Thanks for having me, Hadassah. It's a real pleasure to be invited to this episode. Thanks very much for inviting me.
It's a pleasure on my side, definitely, too. Now, recently, there obviously has been a lot of interest in incorporating artificial intelligence into the boardroom, including in the form of robo-directors. Now, seeing your background, I can imagine that this topic really triggered your attention. What really led you to start researching this area more?
Yeah, to be honest with you, Hadassah, I've always had a keen interest in the area of corporate law, and that's thanks to Dr. Madeleine Taylor. She is a lecturer at Sydney Law School. She always had a passion in this area, and this was definitely contagious. So I regularly attended the corporate law events, which were hosted by Sydney Law School. And one of these events was on the topic of the intersection between the corporate law and artificial intelligence. So even before attending the seminar, I felt like there was such an instant connection with this topic. And when I attended the seminar, which was presented by Dr. Akshaya Kamalna, she is a lecturer at the Australian National University, I thoroughly enjoyed it. So I decided to conduct a research, and my efforts culminated into an article which was published on the Oxford Business Law blog.
Yes, exactly. And that's also where I came across your article and how I found you. Now, I think this is particularly interesting, especially from my perspective, because my bachelor thesis was also on the topic of robo-directors. Now, I focused specifically on the use of robo-directors on the corporate board acting as full board members, whereas I think that you focus specifically on the use of AI by corporate boards and the implications that may have. And what is interesting is that, it's obviously been clear for quite some time that AI is paving a path to major societal revolutions. But I think that it wasn't so clear, maybe, that AI systems would at some point maybe become our equal in terms of business, perhaps. Now, I'm really interested to know what were the origins for the need to incorporate AI into the boardroom context.
To answer your question, I just feel that unfortunately there is no clear answer on how artificial intelligence was actually first introduced to the boardroom. The only thing we can do at this moment is just to make certain speculations on how it was first introduced, and this is based on the example of Alicia T. So Alicia T was a robot which was developed by the Nordic company called Taito. And here we can just make a tentative suggestion that the main reason for introducing artificial intelligence was to actually analyze large stacks of data and make strategic decisions for the company. So here I am just going to mention that this Nordic company, Taito, was actually the first company to introduce artificial intelligence to the boardroom. Another example which followed Alicia T was, I think it's called Vital, and Vital stands for Validating Investment Tool for the Advancement of Life Sciences. And so, according to the Hong Kong based venture capital firm, which actually introduced this artificial intelligence technology, Vital has actually saved the company from insolvency by making strategic decisions on which financial products the company had to invest in. So it's mainly, I would say, that the main reasons for the introduction of the artificial intelligence in the boardroom is to make decisions, to help actually the making decision process for the directors.
Oh, no, that's really fascinating. I remember researching Vital as well. I didn't know all of this, to be honest.
Oh, okay.
um, and what was also really interesting, what I found is that although Vital wasn't really seen as a full board member,
Yeah, yeah, yeah. Just observer status actually. Like they didn't give that technology tool like any like board member, right? Yeah, yeah.
yeah, exactly. It was more of an assistant, you could say. Uh, but still, it was kind of seen as maybe one of the first, real robo-directors. And according to the World Economic Forum, there is also a prediction that by 2025, the first robo-director might actually be serving as a full and autonomous board member. Now, looking at this, I'm really interested because I think your view is that robo-directors will not serve autonomously yet.
Well, I think that there are so many factors that we need to take into account. So, first of all, we need to look at the current legislation. So, I'm not aware of the legislations like in different jurisdictions, but I would say I will just confine my discussion to the Australian context. In Australia, the legislation did not yet attribute legal personhood to robo-directors, and until this happens we can't really talk about robo-directors. Another hurdle which we need to take into account is the fact that the definition of director is very narrow under section 9 of the Corporations Act. So and it requires the director to be a natural person. So I think that we need to require the intervention of the parliament in this regard so they can broaden the meaning of director and we can refer to an artificial intelligence tool as part of the director definition. Until this happens, I don't believe that we can actually talk about robo directors.
And looking at this, can you maybe elaborate a little more on your view on this? Do you believe that robo-directors or AI will be able to actually replace human directors in the near future?
Well, like as I said, because we can't really talk about the existence of a robo director because of the lack of legislation, which would cater for this. I think at the moment we can just talk about the use of artificial intelligence by the directors in order to assist in the decision-making process. So this is how I actually see the role of artificial intelligence at the moment.
And looking at that, obviously there are a lot of questions surrounding this because it's, I guess, pretty shocking to the use of AI in general. Like you said, some like to hold a more, I guess, negative view on it, hoping that it actually won't replace us. But still, it raises a lot of questions, especially in the legal context and especially in corporate law.
Definitely. I mean, as I said, like the corporate law did not yet cater for the replacement of human directors by robo directors, and it did not yet even address the use of artificial intelligence by the directors. So the position is really unclear, and members of the legal profession have just been making speculations generally on the meaning that one should be attributing to the relevant legislation. So there are several provisions in the Corporations Act which talk about like the decision making process. So one of them is the business judgment rule. And the business judgment rule is like one of the safe harbors that is relied upon by directors. So this usually operates as a defense in case like there was any accusation against the director who has breached a duty of care. In such case, well, the director will be able to invoke the business judgment rule as a defense. And in order to successfully invoke the business judgment rule, the director in question must have informed themselves about the subject matter of the decision. So basically, they need to really take an active role in the decision making. They can't just lay back and take a very passive role by just rubber stamping the decision that has been taken by the robo-director, I would say. And this has been made very clear in the Australian case of ASIC and Rich, where they said that the directors must turn their mind to the matter in question. So the expectations here are really high from directors. Like it seems like yes, they can delegate the decision making, but like they still have to assess it and see the merits of it. And there is another avenue for directors to rely on the artificial intelligence. So it's the right to delegate. So under Section 198D of the Corporations Act, directors are usually permitted to delegate certain tasks to another person, but they can only delegate to a natural person. So here my view is that probably the director in question can delegate to a natural person who then relies on the artificial intelligence. So it's basically an indirect type of delegation to the artificial intelligence, and I think that there is nothing clearly that prohibits the director from such delegation. And another and one last thing to mention is the right of reliance. So this is another safe harbor that directors can invoke. And so here the view is that in certain circumstances, a director can be entitled to rely on the information and the advice taken from an employee, professional advisor, expert, or another director. So here I think I'm adopting a similar approach by saying that the director can actually rely on any of these people listed in the provision, who then can actually rely on the artificial intelligence. Because all of the persons listed, they have to be natural persons except for one. The only term in the Corporations Act which is not defined is professional advisor. And here, like I could probably argue that an artificial intelligence tool could be assimilated to a professional advisor. And since the professional advisor does not have to be a natural person, then in this case, a director can rely on an artificial intelligence tool as a professional advisor.
Fascinating. It's also really interesting to see that, while technology is becoming so prominent in our lives, the law doesn't actually cater for the use of AI.
Definitely. I just feel like the legislation is kind of outdated, and I think that the amendments are really long overdue. So we should like really be expecting some amendments probably in the next few years. This really depends on whether we are really moving into a context where the artificial intelligence is really gaining widespread use, or if there is like some kind of rejection that is expressed towards artificial intelligence. Because not all companies have the knowledge, like not all of them have the financial resources probably to invest in these tools. So I would say that each company will be taking a different approach.
One of the points that, or legal issues that we're talking about here is the issue of liability. At the moment, obviously, there's much question about looking then at AI being used by human directors in the boardroom context. What is the what are we talking about when we're talking about liability in this context?
So yeah, as I mentioned earlier, so the first question in order to determine liability is to ask, is legal personhood actually attributed to artificial intelligence? If not, the directors are actually liable. So here in Australia, and I think it's the case for most jurisdictions, if not all jurisdictions, there is no legal personhood that has been attributed on artificial intelligence. So in this case, we are talking only about directors being liable. So the first issue that will arise is the director liability, especially the breach of the duty of care and diligence, which is enshrined under Section 180 of the Corporations Act. So in case the directors have relied for some reason on artificial intelligence, and they were not able to satisfy any of the defenses I have mentioned earlier, which are the business judgment rule, the delegation, and the right of reliance, then they could be sued. And there is a great number of people who can actually sue them. So first of all, they can be sued by ASIC, Australian Securities and Investment Commission. So this is the main regulator of the corporations here in Australia, and the consequences are really quite severe. So here we are talking about pecuniary penalties, compensation orders, and also like disqualification from managing a company. The same consequences apply if other persons choose to sue the directors, and these can be shareholders. So shareholders can actually sue the directors under sections 236 and 237 of the Corporations Act through what we call the derivative action. So derivative actions are usually actions that are taken by members, by the shareholders, and these are in the name of the company. And usually the shareholders will act because the company has not acted in certain instance. Also, I think that another persons who can potentially sue directors are data subjects under the General Data Protection Regulation. So I've done like very minimal research in this area, and it seems like they have so many rights. So and they have the right to be compensated under Section 82 of the General Data Protection Regulation. And I think the last thing I would like to mention is the fact that the directors could actually be sued under the Australian consumer law. So if, say, they have engaged in any misleading or deceptive conduct, especially if they have made any representations about the use of artificial intelligence, say, to shareholders, then they could potentially be liable. And I think directors are not the only persons to be sued. So if we can actually view artificial intelligence only as a product, then we could potentially talk about the responsibility and the liability of the manufacturers of the artificial intelligence. So, especially if there have been any kind of representations or if there have been any kind of warranties that have been attached to the artificial intelligence tool, then I think in this case, not only the directors are liable, but also there is the ancillary liability of manufacturers. That's my view on how liability could potentially be divided among different people.
That's fascinating. I didn't even think about that last point, to be honest, of also being able to hold the manufacturer of the AI system liable. And that really makes a whole situation a lot more complex with a lot more parties, I guess, being involved than just the corporation itself.
Yeah, and the thing that is really interesting is the fact that there has been some discussion about the institution of what they call like the insurance scheme. So this discussion has been at the level of the European Union. So they basically want different people to contribute to this fund, just in case someone has been negatively impacted by an artificial intelligence decision. And to be honest, I just feel like this is not really fair because here we are kind of holding liable people who haven't done any wrong or any mistake. So yeah, because like they can't generate any money for compensation purposes. So definitely we have to reach to the humans behind them, and yeah.
Yes, definitely. And I guess that doesn't make the whole, it doesn't make it easier for, legal professionals here to understand who is liable in what case and who gets compensation when.
I was just wanted to say that I think the liability issue, it operates as a disincentive for companies to incorporate the artificial intelligence as part of the corporate scheme. So I think unless the parliament intervenes with clear amendments regarding the use of artificial intelligence, I think that we can see so much reluctance on the part of directors to incorporate artificial intelligence.
Yes, exactly, which is a shame because it's clear that it has a lot of benefits for the board of directors in terms of being able to understand certain data, make certain decisions, which, humans are limited in what they're capable of. Now, one thing you mentioned in your article on the Oxford University Law School blog is that, well, you gave, I guess, 3 points of advice, and that was that directors should navigate the lawful use of AI through either delegation, forecasting, and the limited use of AI. Can you elaborate a little more on like what you meant by saying these?
Yeah. So I think the first point that I have discussed in my article was delegation. So in terms of delegation, I'm just going to state to you the exact wording of the legislation because I think this would make things clear. Section 198D provides, unless the company's constitution provides otherwise, the directors of a company may delegate any of their powers to a committee of directors or a director or an employee of the company or any other person. So here my view is the words unless the constitution otherwise provides is meant to give some discretion for directors and give them some space to delegate probably to other people or to other things such as artificial intelligence. So I think that directors could potentially rely on this. And just to be on the safe side, legally speaking, they could actually provide for the use of artificial intelligence in their constitution. This will make it kind of legal, although I wouldn't say that this is 100% safe. Another point which I actually discussed was forecasting. And so the issue of forecasting came to mind because I was reading a case. It's an Australian case, ASIC Enrich. And in this case, the court took the view that some decisions are made in anticipation of certain events that may occur in the future. And when this is the case, there is definitely a room for error of judgment on the part of directors. So what the court is trying to say here is that we are not going to be taking a stringent approach. It's rather a relaxed approach, and we will not be really tough on directors, especially in terms of the business judgment rule. We are not going to scrutinize these decisions because the directors are much more well placed to make these decisions, and that the courts are not there to second guess these decisions. So here, because I guess that the artificial intelligence could be used in the area of forecasting, probably a person could rely on this Australian authority to argue that even if there were any errors of judgment on the part of directors because of the use of artificial intelligence, that's going to be okay. And the last, I think the last point was on the limited use of artificial intelligence. So I think that this could be achieved in two ways. So the first one is to really take a balanced approach to using artificial intelligence. So and a balanced approach would really consist in not over relying or under relying on the artificial intelligence, but we really have to raise in the minds of directors the fact that there is something called automation bias, where people will feel inclined to follow the decision of the artificial intelligence just because they think that it is actually correct all the time. And this is not true. So I think that directors should be educated on this risk. And the other thing that I want to mention in terms of the limited use of artificial intelligence is to try to limit its use to only certain aspects of the corporate governance, which are administrative in nature. So I've been reading like some papers, and there seems to be a research paper that suggested the use of artificial intelligence in terms of the preparation of the board meetings. So this is what they consider as administrative type of aspect of corporate governance. So I think if we really limit the use of artificial intelligence to these aspects, I don't think that this will pose any problem in terms of the liability of directors.
Yeah, so this is all really until we have legislation in place that will actually cater for. for these issues. The only thing I'm wondering then, because for example, what the European Union said then was that they were having discussions on so-called e-personhood or electronic personalities for AI. That would mean that, for example, such an AI system, if it could act autonomously, it would also be able to be considered as a director, a fully autonomous director on the board. Now, that obviously also creates a lot of issues in terms of liability when there's no human director who is using it for assistance, but it's the director or robo-director acting autonomously. Um, so while it seems like maybe a good initiative, I think that it will raise a lot of other questions in the same sphere, I guess. Uh,
Yeah, I think was it paragraph 59F, which actually refers to the electronic personalities. They were suggesting that they should be given a separate legal personality. And I think that was met by so much opposition from the industry experts in an open letter which was drafted in response to the resolution which was passed by the European Parliament.
Definitely, yeah, exactly. A lot of opposition because it will lead to other issues, but at the same time, might make room for the use of AI in a way that would benefit companies. So it's really that balancing test. But looking at this, with the possibility of, that robo directors will be serving on the board by 2025. Now, whether that's true or no, we don't know. But how should we move forward from here on?
Well, I think moving forward, there are multiple steps that could be taken. So I was thinking about the auditing of the automated decision making. So this could usually be achieved by evaluating the decision that is produced by an artificial intelligence tool. And in this case, the directors should be assessing the decision that has been generated against any data that the board already possess. But to me, this is kind of productive because the whole purpose of relying on artificial intelligence was to save time and costs. If they will be spending time and energy auditing, then that will kind of defeat the whole purpose of relying on artificial intelligence. And I'm aware of this, but I think to protect themselves from liability, this is an important step that they have to take. Also, I think that they should be liaising with the engineers and the designers who have created the specific artificial intelligence tool in order to design an artificial intelligence that is specific to the business needs rather than just a generic one which could be applied by any company. So they really want to make sure that the data source is appropriate for the specific use of the board. And like talking about like the company strategy, I think that the artificial intelligence tool must be aligned with the values and objectives of the company. And I think that directors should be expanding their knowledge in this area. It's not enough just to rely on the artificial intelligence tool. So, instituting tech committees would be a helpful step. This will actually make easier the dealing with artificial intelligence generally. And I think that tech committees are not the only persons or not the only groups who have to be knowledgeable. I think that also other directors who are not part of the tech committees, they must have certain competencies in this area, just to make sure that that directors are not completely divorced from the reality of artificial intelligence. They have to gain a certain familiarity with it. Another thing that really comes to mind is, again, limiting the use of artificial intelligence. The artificial intelligence is not meant to be a substitute for the decision making and the reasoning of the directors. It's meant to be an aid. So if they confine its use to this aspect of decision making, I think that this shouldn't be a problem legally speaking. And until I think the parliament caters for the use of artificial intelligence explicitly in the legislation, I think it would be better if the directors avoid direct delegation to and reliance on artificial intelligence.
Yes, no, I agree, and I think it's in this context better safe than sorry. Yeah, no, I think there's still a lot to do, and I think it's a really interesting point what you said about the educational side of it, so that directors should be more educated on tech. But I think the other way around too, like the tech developer should know more about how does business work, what are the values of a company.
Yeah, and I think also that since you've talked about the developers and designers, I think it's really important that these persons be independent from the company, because the last thing you want is to have a like an artificial intelligence tool that is biased, because the saying is the artificial intelligence is as biased as the person who has created it. So we really want to make sure that this person is really independent, and they don't have any connection with the company, so they don't engage in self-interest, I would say.
Yes, so definitely. No, I think there's still a lot to be done then in this field, and I think it's really fascinating. So thank you very much.
Thanks for having me. It was really such a pleasure.
Thank you so much for tuning in to the Law of Tech podcast. If you want to make sure you keep up to date with the show and never miss out on an episode, be sure to subscribe on your podcast platform of choice and follow the Law of Tech on social media. If you enjoyed the show, please give it a rating or review, as it helps others discover the show, and don't forget to share it with your network. For now, have a great day, and I'll see you in the next episode of the Law of Tech podcast.